Hello everyone, welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thank you for joining us today. Hey, for those of you who follow Second Amendment issues around the United States, you may be familiar with a landmark decision that just came out of the Fourth Circuit for the United States Court of Appeals, and that's the matter of Hirschfield v. the Bureau of Alcohol, Tobacco, and Firearms, Hirschfield v. A.T.F. Hirschfield, in that case, as you know, challenged a federal law that restricted firearm possession, certain types of firearms, from being possessed by individuals 18, 19, and 20 years old, similar to the laws that we have in the state of Washington. The Fourth Circuit found that that law was unconstitutional. So today I thought we'd spend a few minutes talking about what really are the age restrictions for firearm possession in Washington state. Well, before we get rolling today, remember, if you like this video, go ahead and click that like button down below if you want to stay apprised of all your Second Amendment rights, not only here in Washington state, but nationwide. Go ahead and click the subscribe button down below. And if you want to be notified of any of our new videos, go ahead and click that little bell logo down below. Well, before we launch into all the laws in Washington state, I think it's probably best to first familiarize yourself with the case of Hirschfield v. A.T.F. It is a significant decision. I'm sure that the A.T.F. is appealing for review. Whether or not that will be granted or not, that remains to be seen. But I think the opening lines of this case really, if anything, truly exemplifies the concern that us in the Second Amendment community have about some of these age-restrictive laws. The majority opinion here, authored, opens as follows. When do constitutional rights vest? At 18 or 21? 16 or 25? Why not 13 or 33? In the law, a line must sometimes be drawn. But there must be a reason why constitutional rights cannot be enjoyed until a certain age. Our nation's most cherished constitutional rights vest no later than 18, and the Second Amendment's right to keep and bear arms is no different. And that is a powerful opening to an opinion which would ultimately strike down the law that says that those between 18 and 21 years old cannot possess handguns or semi-automatic rifles. Now, let's talk about the laws in Washington state first. Now, as a general rule, okay, this is a general rule, and we'll get into all the exceptions that we have later, but as a general rule, you cannot possess a firearm in Washington state until you're age 18. However, once you're 18, you can only possess shotguns and rifles, and when I'm referring to rifles, I'm referring to bolt action, lever action, single shot rifles. You cannot possess semi-automatic rifles, AR platform rifles, until you are age 21. Once you are age 21 in Washington state, you can possess both semi-automatic rifles, those on the AR, AK platform, or any other semi-automatic rifle, and that's the age that you can first lawfully possess a handgun or pistol in Washington state. So again, 18 shotguns and rifles. Once you turn 21 in Washington state, everything including pistols, semi-automatic rifles, and so forth. But as I mentioned, there is all sorts of exceptions to the law. So let's start going through some of those now. Okay, now the minimum age to possess a firearm is found in RCW 9.41.040. Specifically, section 2A6, and it reads as follows. A person, whether an adult or juvenile, is guilty of the crime of unlawful possession of a firearm in the second degree if the person does not qualify under subsection 1 of this section for the crime of unlawful possession of a firearm in the first degree, and the person owns or has in their possession or in their control any firearm, and if the person is under 18 years of age, except as provided in RCW 9.41.042. So, as we can see there, and the unlawful possession of a firearm 9.41.040 lists all the reasons for which a person could be ineligible to possess a firearm. It lists all the criminal convictions, predicate offenses to losing your firearms rights, other things that you can do to disqualify yourself from having a firearm. And it does, in fact, bring up the age of 18. However, as you'll see, there is an exception listed right there in the statute, which is RCW 9.41.042. So let's take a look at what that statute says. And it reads as follows. RCW 9.41.040 shall not apply to any person under the age of 18 who is 1. In attendance at a hunter safety course or firearm safety course. 2. engaging in the practice in the use of a firearm or target shooting at an established range authorized by the governing body of the jurisdiction in which such range is located, or any other area where the discharge of a firearm is not prohibited. 3. Engaging in an organized competition involving the use of firearms or participating in or practicing for a performance by an organized group that uses firearms as part of their performance. 4. Hunting or trapping under a valid license issued to the person under Title 77. And as we know, Title 77 is the Fish and Wildlife regulations. 5. In an area where the discharge of a firearm is permitted, is not trespassing, and the person either A, is at least 14 years of age and has been issued a hunter safety certificate and is using a lawful firearm other than a pistol, or B, is under the supervision of a parent, guardian, or other adult approved for the purpose by the parent or guardian. There are other exceptions, including Section 6, if they are traveling with an unloaded firearm in the person's possession to or from any activity described in all the previous sections that we've talked about. Subsection 7, on real property under the control of his or her parent, other relative, or legal guardian who has the permission of the parent or legal guardian to possess a firearm. 8, at his or her residence, with the permission of his or her parents or legal guardian, possesses a firearm for the purposes of exercising the rights specified in 9A 16020 subsection 3, which is our general self-defense statute, or finally is a member of the United States Armed Forces, National Guard, or other organized reserves and is on duty. So as you can see, there is a laundry list of activities in which a person under the age of 18 could be engaged in and still be in lawful possession of a firearm. Now, you will notice that almost all of them require that it be contemporaneous with some sort of organized activity or, more importantly, under parental supervision. Now, there are other exceptions found in RCW 9.41, specifically RCW 9.41.240, which was amended a few years ago with the passage of Initiative 1639. But RCW 9.41240 talks about possession of both pistols and semi-automatic rifles by those 18, 19, or 20 years old, those 3 years of purgatory that young people in America apparently have to go through. And the statute specifically says as follows. A person under 21 years of age may not purchase a pistol or semi-automatic assault rifle, and except as otherwise provided in this chapter, no person may sell or transfer a semi-automatic assault rifle to a person under 21 years of age. 2. Unless an exception under 042, 050, or 060 applies, a person at least 18 years of age but less than 21 years of age may possess a pistol only, A, in the person's place of abode, B, at the person's fixed place of business, or C, on real property under his or her control. The statute also talks about 18, 19, and 20-year-olds possessing semi-automatic rifles, and the statute goes on to say as follows. Except in the places and situations identified in RCW 9.41042 1 through 9 and 9.41060 1 through 10, a person at least 18 years of age, but less than 21 years of age, may possess a semi-automatic assault rifle only, A, in the person's place of abode, B, at the person's fixed place of business, C, on real property under their control, or D, for the specific purpose of 1, moving to a new place of abode, 2, traveling between the person's place of abode and real property under his or her control, or 3, selling a firearm or transferring the firearm in accordance with the requirements of this chapter, provided that in all of these situations the semi-automatic assault rifle is unloaded and either in a secure gun storage or secured with a trigger lock or similar device that is designed to prevent the unauthorized use or discharge of the firearm. So, as we talked about at the very beginning, even though we try to have bright line rules when it comes to the firearm laws in Washington State, the legislature has significantly convoluted things within an attempt, though, obviously in an attempt to give 18, 19, and 20-year-olds some limited access to these types of firearms. Listen, the importance of this Hirschfield case cannot be overstated. This case has the potential to significantly change firearm laws nationwide and specifically here in this state and advance the Second Amendment rights of many law-abiding adults in the United States. I think the court framed this issue quite well when they wrote in the majority opinion as follows. Plaintiffs seek an injunction and a declaratory judgment that several federal laws and regulations that prevent federally licensed gun dealers from selling handguns to any 18, 19, or 20-year-old violate the Second Amendment. We first find that 18-year-olds possess Second Amendment rights. They enjoy almost every other constitutional right, and they were required at the time of the founding to serve in the militia and furnish their own weapons. We then ask, as our precedent requires, whether the government has met its burden to justify its infringement of those rights under the appropriate level of scrutiny. To justify this restriction, Congress used disproportionate crime rates to craft over-inclusive laws that restrict the rights of overwhelmingly law-abiding citizens. And in doing so, Congress focused on the purchases from licensed dealers without establishing those dealers as the source of guns 18 to 20-year-olds use to commit crimes. So we hold that the challenged federal laws and regulations are unconstitutional under the Second Amendment. Despite the weighty interest in reducing crime and violence, we refuse to relegate either the Second Amendment or 18 to 20-year-olds to second-class status. That is powerful language there, and I think it tells us where this court is going with it, and hopefully if this matter is accepted by the United States Supreme Court, we will see a similar opinion. Listen, as a general rule, you have to be at least 18 years of age to possess a rifle or a shotgun. You have to be at least 21 years of age to possess all types of firearms, including pistols and semi-automatic rifles. But there are, as there is with many things in Washington law, a lot of exceptions. You may have more questions about age restrictions or anything related to your Second Amendment rights. And if you do, don't hesitate to contact us at WashingtonGunLaw.com. Or you can call us directly at 425-765-0487. Listen, part of being the lawful and responsible gun owner, like we preach all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.